Hi there, this is Dawn Haley, the Dawn Podcast. I want to thank you for tuning in to my first episode. I'm so happy and finally able to get my podcast off the ground. And so, my first guest, and I'm so proud of this young lady because not only am I watching her grow in herself as a real estate attorney, estate planner, and probate. She's also my daughter. So I am going to put on my professional hat and take off my mother hat so that we can have a informed discussion about her area of expertise in the law she practices. So welcome, Lisa Glenn, the law office of Lisa Glenn. And we're going to talk a little bit about probate and estate. Sadly, we are losing a lot of our loved ones for a variety of reasons. And oftentimes, our loved ones pass away without a will, without any pre-planning in the event that unfortunately they pass away. And so oftentimes when that happens, families are trying to, scramble around to try to figure it out. So, Lisa, welcome. Thank you for
Hello.
taking time out of your busy schedule. I know with COVID now, the courts are opening up, so your life is getting a lot more hectic. So I appreciate
Yeah.
you taking time. So why don't I just let you introduce yourself? You can tell a little bit about yourself and some of the things that you practice in your law.
Well, hello. Thanks for having me. Very honored to be your first guest on the Dawn podcast. Um, you know, as you said, my area of expertise, as you would say, is probate, which essentially means when someone passes away and they need to move their estate over to their heirs, either through a will or if they died without a will, who are legally obligated or legally owed parts of the estate. So that's one area of law that I practice, and I also do adult guardianship in the probate courts, which essentially when someone is no longer able to handle their financial affairs or their medical affairs. Typically, it's because of a medical condition or age. They get a guardianship appointed over them. So that's another part of the law that I practice. And then I also do real estate. So when people are having their closings, buying or selling, in Illinois, you want to have an attorney with you because an attorney is necessary for the process in Illinois because it's not as simple as it could be in other states. And lastly, estate plans, and I think that's going to be the estate plans and decedent estates are going to be, the focus of the conversation. And estate plans are essentially making sure to plan your family's making sure your family does not have to go through too many hurdles to move your estate when you're unfortunately no longer here. It's even more important now because a lot of people are unfortunately passing away and passing away in a way that we would have never thought because of this global pandemic that no one would have ever saw coming. But there's unfortunately lots of death going on and not a lot of preparation for it. So.
And that's one of the reasons why I wanted to have you on, because unfortunately, when there's a epidemic or a tragedy, there are people out here that take advantage of people's vulnerability when they're in situations like that. So let's talk about, let's say, for example, there are families that they've lost a loved one, and the loved one does not have a will. And so let's throw a little mixture in there that the families are not happy with one another. they they don't trust, and they have a trust issue. So is it often do you often find when there's not a trust issue, are the families left out of the process, or how does that work?
So in Illinois, and I can only answer for Illinois, and all states have their own procedure, but in Illinois, if there's no will, everything legally is supposed to be divided up among the heirs, and it's divided in a way, it's called per stirpes, but essentially it means you go to the next generation. So if someone passes away and they didn't have any children, but they were married, everything would go to the spouse. If they pass away and they didn't have a spouse, but they had 4 children, it would all be split evenly among the kids. If they pass away with a spouse and kids, it would be split between the spouse and the children. Um, and what I've seen happen when there is discourse among the families, that there are some families that intentionally leave others out, and the way they can do that is by essentially lying to their attorneys, and it happens unfortunately more than it should, because in Illinois there's an affidavit that has to be signed as far as who are heirs, who are legally owed parts of the estate. And if someone who doesn't have scruples and who doesn't necessarily get along with their family, they can easily say, "Oh, well, these people, this is the heirs, and this person is not," or they'll intentionally leave names off the affidavit. And I've seen it happen more than once. And I've also seen situations where everyone is listed, but because there's money involved, it now becomes a fight that doesn't need to be there if someone would have left a will saying, "Well, I want my things to go to this person," as opposed to everyone now having a piece of the pie and having a what they feel is a say in how everything goes. So
Yeah.
it just
So,
starts fights that don't need to be there.
right. And as a realtor that I've of course I've been a realtor for 30 years. I've had situations, unfortunately, where family members don't get along, and it's difficult because as a realtor I represent the estate and I represent everyone, so I can't pick and choose who's my favorite over the other. So when a, so if it's so if it's so if it's a situation where the siblings don't get along, and they have lost a loved one. So, do you recommend that these siblings seek out an attorney themselves to make sure they're not overlooked? What do you recommend so that, let's say, if there is a some frictions or schisms between families, how can a particular family that isn't in the loop, shall I say, how can they ensure that they're going to be considered in the estate?
Yeah, and this isn't it sounds like an attorney answer, but it really isn't. But it is imperative if there is friction among the families that each family member reach out to their own attorney, because when you have sometimes in certain areas of law, when get attorneys involved, it ends up being a bigger fight. But in probate, we always like to call it family law light or family law diet family law, because a lot of the attorneys, we try to be as collaborative as possible to make things go as smoothly as possible. So if you have family members that have their own attorneys, you have the attorneys working to make sure that there's not too many heads being bumped against each other, and making sure that all of the legal rights to each person is being adhered to. So, a lot of times clients will come to me and they'll let me know all of the heirs, and I'll send notice to all the heirs, and the heirs call me asking me all these questions, and it's like, well, I'm not your attorney, so I can't really answer too much. If you have specific questions, you're going to want to reach out to your own attorney, because unfortunately I don't represent the heirs. I represent whoever's being named as the administrator. um, and it's not easy law to decipher sometimes. So if there is not friction, sometimes people still get their own attorneys to read and understand everything that's happening. If there's friction, you definitely want to have a third party making sure everything is going the way it should legally, and as the statutes say.
Yeah, yeah. And again, like I said, I have in my experience, I've had family members who don't get along with each other, and only one attorney is handling it. And
And that's been me on more than one occasion. It's never fun.
yeah, and it's and so obviously, death does unfortunately bring out that,
Yeah.
and it's sad, but it's one of those things that we, as professionals, we have to be, aware of, and how to inform people how they have to navigate through that. So we're going to take a break, and we're going to come back, and we're going to talk a little bit more about the various parts that people play in estate planning, and so that you can get some information and maybe share it with someone, or if you're going through it yourself. So we'll be right back.
Love don't cost a thing. There's hearts for cards, but cash is king. Fancy cars and diamond rings. I won't get caught in all that greed. So come and take a walk in peace. There's all the freedom you need. And go spread your love for the people's greater needs. Take a walk in peace and hear what I'm saying now. The world is obsessed with material things. It's time to throw away your selfish needs. Let's let your words agree with how your actions speak. I'm here to talk, not trying to preach. So come and take a walk in peace. There's all the freedom you need. And go spread your love for the people's greater needs. Oh, yeah. Oh, yeah. Don't let yourself get lost in all that greed. Oh no.
Okay, counselor, we're going to just recap our conversation regarding families who unfortunately may have differences, that they may be concerned as to whether or not they will get their portion of the estate, of what that might be. And so, was it fair to say, as you discussed earlier, that would be to their advantage to seek an attorney to represent them? So you go ahead and you pretty much wrap that up, so that I am not speaking the legal side of it, you're speaking it, because I know how to stay in my lane as a realtor.
Oh wow. Yeah, no, yes. And I do want to have a caveat though. I absolutely recommend having your own attorney if there is a substantial estate to not fight over, but to split. If the only thing in the estate is a house that nobody really wants, or no one's willing to take care of, or no one's trying to sell and receive proceeds from, I know this sounds religious, but just pray on it. Like, there's no reason to bring attorneys in and having all of these people in your business if the estate isn't even large enough to justify that type of, I don't want to say headache, but that type of involvement. So I will say that you
Yeah.
definitely want your own attorney. If there's an estate where there's a decent payout, and you just want to make sure you're not left out from that. Absolutely, but families tend to fight over the smallest things. So if there's a 1999 Buick or something in a property worth $10,000, if that's what people like to fight over, and it's not worth that to have all the discourse among the family. But that's my 2 cents. I mean, at the end of the day, if you do want to make sure you're not being overlooked, get an attorney, but try to work together.
Yeah, I mean, of course, in the real world, you want people to work together, and and unfortunately, death sometimes brings out
the worst people.
Yeah, I'm glad you said it. I didn't say it, but let's talk about, okay, we discussed, representing, making sure you're properly represented in an estate planning or probate situation. Now, you alluded a moment ago about real estate. In your practice, do you normally find that there is real estate that needs to be disposed of?
For me, because the type of clientele I try to help the most are those who are not necessarily high income people, and those families, 9 times out of 10, the only real asset in the estate is a piece of property. I would say 90% of my probate clients, the reason they're in the office is because there's a piece of property that they're either living in or they want to sell, but they can't do it because they don't have the proper paperwork to do so, because the person who owned the property has passed away. So those are the main types of clients I work with, because again, my target clientele are those who aren't, essentially who I try to help are people who aren't rich and can afford the crazy hourly $500 an hour, $5,000 retainer attorney, and those who also make too much to get legal aid help. So I'm trying to get that middle class family, and like I said, most of my probate clients are those who are, it's a piece of property, and that's the estate, and that's what they're trying to move to the heirs.
Right. And in my experience, because as my daughter Lisa Haley and I, we do work together on properties that need to be sold in an estate.
She meant Lisa Glenn, y'all, just so y'all know.
I'm sorry. Yeah, I'm sorry. I'm still on. Please forgive me.
I'm still a Haley though, but just for identity purposes, she means Lisa Glenn.
That's what I meant. Thank you for correcting your mother. But most of the time when I'm working with attorney Lisa Glenn, it is handling an estate, a property that needs to be sold. And what I try to do in working with counselor is to not give the property away, understanding that yes, we need to dispose of it, but we want to definitely try to get the highest best offer. But in that process of when there isn't a will or some sort of instrument that dictates how the property is to be disposed, what has to happen in order to get a family that's grieving from to get that property in a position where now they can move it to getting on the market and sold? What does that process look like?
So there's 2 processes. One is not used too often, and it's essentially going through the title company. And going through the title company, you have to make sure all of the heirs are in agreement, and they have to understand that a large chunk of their proceeds are going to go to the title company, because the title company is going to charge at least a 5 to 10% on whatever the value of the property is, and then they have their own title charges, and you got your attorney fee. There's a lot. It's just a lot more extensive to go that route. But the process that I use most as the attorney, what I usually recommend, because it's less costly, is to go through the probate process, which is going through the courts. And essentially what you're trying to do is name an administrator over the estate. So, and let me just go back. There's only really 3 reasons you need to go to probate. And that's if there's an estate that's over $100,000. So if there's liquid assets, let's say bank accounts or savings accounts or something that are over $100,000, you would need to go through the courts to move that money to whoever the heirs are. If there is a piece of property and there's no trust, the property is not in a trust, then that has to go through probate. And if there's any disputes among the heirs, then you'd have to go through the court system to get named an administrator. So if there's a piece of property and that piece of property was not put in a trust, and all the heirs are not in agreement to pay, a substantial amount of money to the title company to get the property sold, you want to go through probate. So with probate, you're trying to get an administrator named, and that administrator is essentially the one who's in control of making sure the estate is moved properly. So let's just, take it simply. If there's a piece of property that was not in a trust, let's say you have 3 siblings, and the 3 siblings agree that, the oldest should be the administrator because they're maybe the most responsible. So that person would file a petition in court, pay all the court costs. There's court costs. You have to pay the filing fee. You have to pay a publication fee. You have to pay a insurance premium fee, and your attorney's fees. Pay that, get the petition filed. About 30 days later, you'll get appointed administrator. Once you're appointed the administrator, you'll get letters of office. And those letters of office are your official paperwork saying that I am in the position to, sell the property, transfer the property, go to the bank and take money out of the, bank, and, just do whatever you have to do for the estate. But there's a 6-month period where creditors have the right to file claims. And if they file claims and there's money in the estate to pay those creditors, you have to make sure those creditors get paid off the top, and then you would split whatever's left over to the heirs. And if there's a property that you're trying to sell, you can sell that property before that 6-month period is up. You just can't disperse any money to anybody until that 6-month period is up. But it's it's a process that takes anywhere from 6 months to a year, and it's something that could be avoided if a proper estate plan is in place.
So I'm glad you brought that point out, and we're going to take a break, and we're going to come back, and we're going to talk about what do you feel is the best situation that a person should be. I mean, you obviously should do something really before, unfortunately, someone passes away. So we're going to have that conversation in our next segment. And meanwhile, enjoy the music that we're playing. So we'll be right back. right, we're back, and I hope you enjoyed listening to the sounds that are part of my broadcast, my podcast. I just don't want you to hear our voice. I'd like for you to go ahead and enjoy as well as learn. So anyway, we're just going to recap what we just talked about, counselor. So it sounds to me, and I'm just trying to think about someone who's listening. It sounds to me that if you can avoid the process of probate from the very beginning, it would be good if families could sit down at the table and talk about the thereafter. Is that what I'm kind of understanding or feeling, that that's, a better approach? And then when they come to you, all the ducks and everything is in a row, then you just have to process it. Is that kind of the thinking?
That is 100% correct. That's 100% correct. I mean, like we were said earlier, death brings out really ugly sides of people. So if you can take away a stressor, it'll make things just go a lot smoother for the family. So one of those stressors is having to go before a court and petitioning the court for anything, having a judge in your business, and having to pay, attorney's fees that are probably double or triple what you would have paid if your family member who unfortunately passes away would have paid to have their estate set up. So in Illinois specifically, I always recommend if you have kids and a piece of property, you want to at least have a will, a trust, and or a transfer on death instrument. And a transfer on death instrument is essentially a document that gets recorded with the county that states who you want the property to go to after you passed away. I usually recommend transfer on death instruments when the property is already paid off, or if it's only one property in the estate. If it's multiple properties, sometimes a trust may be better, because you can put all the properties under one trust, and then you can put in your trust who you want things to go to. But a transfer on death instrument if you have multiple properties, it'll work just the same for the multiple properties as well. But what a trust can do is it can name one specific person to be in charge of your properties, as opposed to saying, I want this property to go to these people, but now you have these people who have to work together to make sure that the property is properly distributed. So my advice is always, if you have children and you have a piece of property, get a trust, get a transfer on death instrument, because that's the best way that you can avoid going to probate. And if you have, like I was saying, if you have more than $100,000 saved up somewhere and you have bank accounts everywhere, designate a beneficiary on your bank accounts, because then again, you wouldn't have to worry about going through probate, because someone's already named as to who's supposed to take charge of the bank accounts from there. But yeah, it's just, probate is something that is easily avoidable, but for some reason people don't take advantage of the ways to avoid it.
Right. And I think since most of your clientele may be struggling to have the finances, or may not, have the resources where they can learn about this information, so that it's not, when death occurs, then now, families are trying to scramble around, and that's so easy for people to be taken advantage of, because if you don't know, you assume that people that come in your face and they're telling you, a nice sounding story, that they're not necessarily looking out for your best interest. So that was one of the reasons why I wanted to have you on my show, because obviously your area of law is an area that I do a lot of my business. And so I like for people to at least know that, that if they come to you for your services, which I hope that they do, that you have a professional realtor who happens to be your mom that can take care of them and not and look out for their best interests. So we're going to recap and just really talk about maybe some terms that people should sort of understand. A will, you want to just kind of.
I think what I always want to say about a will, most people's most common misconception is if they have a will, they won't have to go through the probate process, and that's not true. If you have over $100,000 of assets or a piece of property, so if you have one of those, a will is not going to keep your family out of probate. That is probably I'd say of people who have of people whose family members left them wills. Again, another 90% of them didn't realize that they still have to go to court because there's a piece of property that was not put in a trust or there was no transfer on death instrument. So I think that's the biggest misconception. But if you have a simple life, if you just, if all you want to make sure is that you're cremated when you pass away, you want to make sure that's in writing or something, or if all you have are some old jewelry boxes from your grandmother or something, you want to make sure it goes to somebody, then a will is absolutely needed to make sure that there's no issues when you're no longer here. But that's essentially, a will is just stating how you want things divvied up, how you would like your funeral, if you want special instructions for that, how you'd like your final resting place to be. You'd want name that type of stuff if your estate is really small and really simple. And when I say small and simple, I mean no property, nothing over $100,000 in any liquid assets.
Misconception that people have is that if they have a will, that protects their right to be in position to handle the affair. And another thing that I find that people also have, they get assurance with, which I don't think it's totally full assurance, is they feel as long as they're the power of attorney. So explain,
that's another. I get that a lot as well. I have clients who, have a parent who passed away and they have a sibling who had power of attorney who's taking over everything after the parent has passed away. And the common misconception with power of attorneys is that the rights of a power of attorney go beyond death, and that's just not true. About power of attorney, the definition of a power of attorney is essentially being a person's spokesman while they're alive but can't speak for themselves.
Yes. Right.
Once
Absolutely.
they pass away, the power of attorney is expired. The power of attorney leaves with the person. So I get a lot of clients, not a lot, but I get a number of calls from potential clients who essentially said, they have someone like a sibling or a cousin who was power of attorney, and they're taking over everything, and that's just not that's not how it works. That's not how that works. Once the person passes away, the power of attorney passes away with it. If there's no will naming someone as an executor, then the person who's named power of attorney has no powers to do anything.
And again, and I thank you for that, because and that's what I, as I'm doing business with families, I always hear, well, I have the power of attorney, and the person has passed away. And I say to them, well, I'm not an attorney, but that, I believe, is when the person is living. And so you just confirmed that thought as well. So ladies and gentlemen, if you
there is one in Illinois, at least. In Illinois, there's one exception. The only thing that a power of attorney can do after a person has passed away is dispose of their, like if the person wanted to be a donor, they could put that on their power of attorney that they would want, their organs donated. That's the only thing a power of attorney can do after the person's passed away. So.
Right. This has been great, and I appreciate you coming on my first show, and I'm excited because, number one, you're an attorney, and so why don't you take this time to just For those that really enjoyed what you presented today, give them your information so that um, they can reach out to you if it's nothing else to ask you some questions. One of the things you said earlier is that you're not one of those attorneys that charge out. I mean, granted, this is your livelihood, but at the same
I do
time,
have bills, but I'm not
you
trying to
do have
make
bills.
anybody poor.
You have bills, and you understand the clientele that you tend to serve don't have a lot of money. So to have an attorney who's very astute and wise and really puts forth the effort to represent their client is good, that you're available to help them. And so that's great. So give the audience your information, and so that they can reach out to you should they have some questions, or sadly they need your services.
Yeah, so you can find me you can check my website out, which is lglennlaw.com. I'm very forthcoming with my prices. My prices are even on there, and there's not a lot of attorneys that will do that. So you know exactly what it is that you'd be looking at if you reached out to me. Yeah, so I can be found. I have a website, lglennlaw.com. It has all my contact information. I'm also on Facebook, Law Office of Lisa L. Glenn, LLC. And I'm very transparent with my prices. My prices, if you go on my website, they're listed there. There's no surprises. There's no gotchas or anything. I really am focused on trying to help clients who need the legal assistance but can't always afford what most attorneys are trying to, nickel and dime you out of. So, yeah, visit me on my website and on my Facebook.
Yes, and thank you again. And if you have any questions, please feel free to reach out to Lisa Glenn. And in terms of any real estate needs, you can contact Dawn Haley at asagarealty.com. And so thank you again for taking time to listen. And I hope something that was said today will enlighten you. If you have a loved one who needs the services that we offered or talked about today, or you just need some answers. So, but everybody, thank you again. Enjoy. If it's night, evening, day, enjoy, and look for my next podcast, which will be coming in a couple of weeks. So take care, everybody. All right, Sire, take us out.
Everybody be safe out there.